passed away. There are some things that have changed for retirees during their lifetime as well, but those are relatively minor in comparison to the impact that the end of life changes have created or will end up creating for those people. In particular, it really impacts the length of time that beneficiaries have to take those out. So welcome again, everybody. I'm attorney Justin Randall with Hooper Law Office. Our topic today is on the Secure Act. So that is if you're curious about that, if you haven't heard about it, or if you have heard about it, great, you're kind of ahead of the curve there. But if you haven't heard about it, it's a law that passed in early 2020 regarding how retirement accounts, qualified retirement accounts, function somewhat during people's lifetimes. Some of the rules around that have changed, although those are relatively minor in comparisons to the changes that they have created for the people who are inheriting those accounts. The biggest tax implications, the biggest sort of life implications for that definitely impact the beneficiaries of those accounts a lot more than they impact the original holder or owner of those accounts. So before I get too in depth on sort of what that all entails and what the requirements of that new law are and what it allows you to do as a retiree potentially, before we go too in depth into that, I just want to remind everybody that if you have questions, we do have a Q&A function, so you can shoot me a question within the Q&A box or the chat box, and I'll see those pop up. Next week as well, as a reminder, is our first in-person webinar, or what that would not be a webinar, a first in-person seminar, public seminar, coming up next Wednesday. It'll be here in Appleton. It's our wills versus trusts. So if you want to sign up for that, seating is limited. The capacity requirements of the facility are still a little more limited than they would be normally. So it is if you want to sign up for it, it's actually at estateplanningAppleton.com is where you can sign up for that. But it's absolutely something that we can hope to see you there for next week. Another thing as well is you'll get a feedback form from this, where that is where you can fill out if anything I bring up today raises any concerns for you, and you say, oh, I need to get my estate plan looked at to deal with these law changes, or maybe you don't have an estate plan in place. That's totally okay to come in and talk to us about that as well. That feedback form is a place for you to fill that out and let us know that you would like us to reach out to you and set up a time to talk. Those are complimentary initial consultations. They don't cost you anything to come in and talk to us. They're set up for usually around 2 hours. So expect that amount of time, I would say, in terms of sort of budgeting time, but we can be flexible too. I mean, if it's something that you don't have that amount of time, just let us know and we can work around it. Okay, so to get started in here and about this Secure Act change that occurred early 2020, really the biggest changes, like I mentioned, occur after someone's passed away. How they have to, how long a beneficiary has to take out these accounts is really the biggest change. But to start with, I'll talk a little bit about some of the changes that occurred for the original account owner. So if it's your IRA or your 401k or 403b, really any sort of qualified retirement account that has tax deferred, you put it in ahead of time and you don't pay the tax on it when you contribute, but you pay the tax as you take distributions. But these laws also impact Roth accounts as well. So Roth accounts being the ones that you have paid the tax on going into those accounts. So it used to be, prior to this law change, that the original account owner of an IRA, once they retired, they didn't have to start taking required minimum distributions right away at retirement necessarily. But once they turned 70 and a half, that's when they had to start taking out what they called required minimum distributions. So that was based off of your life expectancy. That is saying, okay, based off of the life expectancy of a like a 72-year-old, 73-year-old, here's how much you have to take out of that account this year. And the reason they did that for pre-tax retirement accounts is because they eventually want their tax money on it. But that 70 and a half has actually now been upped. So if you are the original account owner, that has been changed to 72 years. So you can actually wait until 72 unless you turned 70 and a half prior to this law change. So I do see a question coming up. I have a revocable living trust. What are the benefits of putting my home deed in the name of my living trust other than not having to go through probate? Are there any advantages? To answer that question, having a home in a living trust, it really makes sure that it avoids probate, but it also depends on other planning that you're looking at doing. If you're looking for like asset protection for your children, or you want some other restrictions placed on things, that's really beneficial for a living trust. And in particular, if it's not owned by the trust and you're not, you're leaving it directly to the beneficiaries, maybe by like a transfer on death deed rather than the trust. So you're still avoiding probate. That can impact potentially, the ultimate split of your plan. You sort of want one central point of control, but it also doesn't provide any sort of backup contingency planning for what happens if you don't know what is going on in the beneficiary's life. So what I mean by that is, for example, maybe you're leaving it to somebody and maybe they have a substance abuse issue when they inherit that you didn't know about at the time. You don't want that person in control of those assets. So just leaving something to somebody and not having it funnel through a trust or a will can be really dangerous, honestly. Now, it's not always the case that always creates problems. It's just something you absolutely need to know, that if you leave something directly to somebody, that can, without having it be first controlled by a trust or going through probate, that can create problems. It also provides some tax planning in a trust that you wouldn't necessarily have through just a direct beneficiary designation. The step up in basis still occurs, but there's some other tax planning too. Okay, so to get back to the Secure Act, one of the things that also changed for retirees, or not retirees, I should say, the original owners of those accounts, the big thing is you can actually now continue to contribute past age 70 and a half. So it used to be under the old rules, once you turned 70 and a half, you could no longer contribute to an IRA. You had to just start taking out the money, and you couldn't add anything new to it, even if you were still working. Well, that changed now so that if somebody is continuing to work past age 70 and a half, they can continue to contribute as long as they're working. Now, they still have to take out their required minimums if they're over age 72, but that doesn't mean they also can't then contribute to it. So not everyone, hopefully, if you want to retire prior to 72, you're able to do so, but some people like to continue working to past that point. So that's a big change. The biggest change, though, and this is where it really impacts our industry, our estate planning industry in particular, is how it impacts beneficiaries. So under the old rules, and this is prior to 2020, if somebody passed away prior to January 1st of 2020, any retirement accounts that somebody inherited, they had to start taking required minimum distributions right away. However, those required minimum distributions were based on their life expectancy at that time. Never got recalculated. It was, if I was a 25-year-old and I inherited, I'd have, I forget the exact table amount, the life expectancy table, but it's somewhere in the neighborhood of like 50 years, 52 years maybe. So I would have at 25 years, 25 years old, I would have 52 years to take it out, but I'd have to start right away. The way that has primarily changed is that life expectancy, life stretch, no longer is available for the vast majority of beneficiaries. So what that means is that 25-year-old no longer has 50 something years to take out that account. The new way that works is the beneficiary has a maximum of 10 years to take the entire balance of their share out for retirement accounts like that in particular. It doesn't impact non-retirement, non-qualified assets. This is only talking about qualified retirement accounts. Those assets, if somebody inherits those, they have 10 years to take the whole thing out. That does not mean that they have to take out 1/10 every year necessarily. It's the way the rules were written is it essentially says by the end of year 10, you have to take out all of that, the balance of that account. So if it's $100,000 and you wait all 10 years, you have to take out $100,000 in taxable money. If it's a traditional IRA or 401k. So obviously that, if you're doing the math here, that increases the tax liability for those beneficiaries. If I was taking out 1/52nd of 100,000, well, I'll make my math a little easier on myself. If I was taking out, say I got $52,000 of an IRA and I was taking out 1/52nd every year, well, an extra grand of income is not going to bump my tax bracket up necessarily all that much. It's not a huge additional tax liability for that person to bear the burden of. Well, if I have to take out an extra 5 grand every year, that may. And that's a relatively small amount I'm talking about. But the bigger concern here is when somebody maybe has, you see this with a lot of, surgeons, for example, they have pretty high balanced retirement accounts, maybe in the $1 million+ range, almost certainly. Well, if I'm inheriting $1 million from an IRA, I no longer get a huge lifetime stretch on that tax burden. I have to take out $1 million over 10 years in taxable income. And that almost certainly would bump someone up, a couple tax brackets at the very least. And like I said, you can wait until the end of year 10 to take out everything. But if it's a pre-tax account, you're just making the tax burden even worse, because now you're taking out $1 million in 1 year, which now you're not talking about, maybe the 30% tax bracket, but the 37% tax bracket, right? So, well, definitely the 37% tax bracket at that point. So this has impacted a lot of things with planning during your lifetime of how you can help avoid this, or at least prepare for it so that the beneficiaries have the best stretch possible, or the best tax planning possible, I should say. The stretch is kind of a little more difficult to avoid, or the 10-year limit is more difficult to avoid. So one of the biggest things that we're talking to people about doing in coordination with their financial planners and their CPAs is during your lifetime, looking at sort of diffusing the tax liability. So the biggest misconception that people come into that discussion with, generally speaking, is, well, I was told to defer all these taxes. We never want to pay taxes. That's a terrible thing to do. It's, the worst thing anybody can do is ever pay taxes on anything. Well, deferring those taxes is not, sounds great initially when you're saying, oh, I can let it grow and then only pay the tax as I take distributions out. Well, that was, not the worst case scenario initially, but what happens now under the new rules is now it's a huge tax liability for anybody inheriting because of that limited stretch. So the biggest thing we're recommending people to, look into anyway, is looking at Roth conversions. So you generally don't do this while someone's still working, right? It involves a lot of tax planning and sort of tax bracket planning for people. But this is when you might look at talking with your financial advisor and your CPA and say, hey, I want to, give my kids the best possibility here, and so that they don't have to pay a huge amount of tax on it. And that's when your CPA and the financial advisor get together and say, all right, based off of your tax bracket, where you're at currently, you could convert some of your traditional retirement account to a Roth retirement account without bumping yourself up into the next tax bracket. So why you generally wait until someone maybe is retired to do this is, if you're still getting a salary from your job, it's harder to do this efficiently. Whereas somebody in retirement is generally making less in income because of maybe Social Security, or maybe they're pre-Social Security still and aren't getting any income or very little income. So you can move a lot more with somebody in a lower tax bracket. Now, this involves paying the tax on it, of course, and this is something that a lot of people try to avoid doing ever, and I understand the feeling behind that. But the reason you look at doing this during your lifetime is because you have, generally speaking, a much longer time to convert that retirement account over to a post-tax Roth account. You have, hopefully more than 10 years to do that. Whereas your kids or your beneficiaries, their 10 years is that's how long they have, unless they meet a few very specific exceptions that I'll get to in a second. But the reason that's a huge concern, and the reason you want to look into it, is, well, you can help lessen their tax burden then when they inherit it, and actually maximize the value of your estate for them. That's the big goal here, is not just so the kids don't have to pay taxes on it. That's a huge benefit. But also, if you have $1 million IRA going to your beneficiaries, you want to try to maximize that value for them, rather than, potentially do no planning at all around it and have them pay a huge amount of tax because of that 10-year limit. This is a strategy that is heavily involved with the CPA and the financial advisor, because they're the people who really kind of work with the numbers on a day-to-day basis and see you on a really regular basis to help you do this type of planning. Would not recommend somebody try to do this planning without talking to their, advisors on this, because it's so situational. I mean, it depends so much on your own personal tax brackets, and you also need to look at what your kids' tax brackets are and what they're likely to pay if they inherit it. So it's a pretty involved calculation. But the reason it's so beneficial, on top of just not having to pay taxes as they take distributions out of a Roth account when they inherit it, they're still limited to that 10-year rule. It's still, at the end of year 10, they have to distribute that account. But the huge plus of it is Roths also grow tax-free while the financial, while it's still in that account, while the money is still in that account. So if I inherit $100,000 in Roth, well, I don't have to touch it for 10 years. And then if I take it all out at the end of year 10, I don't pay a dime in tax on that, right? It grows tax-free for me. So not only are you making it so that your children don't have to pay taxes as much on it, or maybe lessening the amount of taxes they have to pay on it, but the best thing in the world to inherit is an account that you can let sit for 10 years, grow tax-free, and then still not pay any tax on it. I mean, that's the biggest benefit for this Roth conversion. So one of the things that has changed with, like I mentioned, there's a couple different exceptions now to that 10-year rule. So the spouse, if it's a surviving spouse who is inheriting a retirement account, they still have their lifetime stretch. I mean, that's still a spousal rollover. So that hasn't changed in that sense. You can still leave it to a surviving spouse without having a 10-year payout, as long as it is left to that surviving spouse. So that lifetime stretch is still there. Now, one of the other aspects here is if the beneficiary is a minor child of yours. So if they're a minor child, if I'm leaving a retirement account to a 10-year-old, for example, well, that 10-year-old doesn't have just 10 years to take it out. They actually have, up until age 18, they get their life expectancy. And then from that point on, with some other exceptions, they have a 10-year payout. So that they wanted minor children to not have a 10-year payout because they're also minors, right? It's the benefit there is that they can take it a little longer as if it was supporting them. So a minor child is a huge beneficiary, or is a huge exception to that, but it does have to be a minor child of the account holder. So it can't be like, oh, I'm leaving it to my great grandchild. They're not a child of yours, right? That's not the right exception there. It is pretty limited in that sense. Another, and this was the weirdest one that they wrote, I think, just because of the way they worded it. But another exception is if the beneficiary is not more than 10 years younger than you. So not more than 10 years younger, you definitely know, okay, if somebody is within 10 years of my age on the younger side, I understand that means they get their lifetime stretch still. But the way most people are reading this, and myself included, is that also includes people who are older than you, because they are not more than 10 years younger. Now, there's not been a ton of opinions written on this by the IRS yet, that I'm to my knowledge, but that could be that if you leave it to a sibling, for example, who's an older sibling, maybe you don't have children of yours, they get a lifetime stretch still. Now, if they're a much younger sibling, if they're 20 years younger for some reason, which I suppose can happen, they are still stuck with that 10-year rule. So it's, like I said, it's a very weird exception, a very limited one. But if you can use it to your advantage, that means that in terms of somebody's estate plan, you might use who you designate some of these accounts to might change. Maybe it's not just equally across the board to everybody, but in order to maximize the value, maybe you give one beneficiary more of a certain type of retirement account, right? So the other couple aspects here that they gave some exceptions to in terms of who gets a lifetime stretch still is if a beneficiary is chronically ill or if they are disabled, meeting the requirements under the the Internal Revenue Code. So basically under the rules of the IRS. Essentially, it means that you can't engage in gainful employment or gainful activity is the way they define it, I believe. And that is a little loose of a definition, right? What constitutes gainful activity or, some sort of activity you're engaging in to get paid. So if that is an individual that you're leaving things to, that they're under some sort of, maybe they're receiving benefits and they're on a disability, or they're subject to those restrictions where they are considered a disabled individual or chronically ill, they do not have to have that 10-year payout. That is just any sort of chronically ill beneficiary. So there are, it used to be as well, prior to turning age 59 and a half, if you took out early withdrawals, you were penalized kind of across the board, right? It would basically be a 10% tax on top of whatever the tax bracket would be. Now there are certain certain withdrawals that prior to age 59 and a half are no longer penalized. Still very minor, still not a huge benefit in a lot of ways, but a couple things that somebody might be able to take out ahead of time prior to turning 59 and a half. So if you are, paying for the birth or adoption of a child, you can actually take out a maximum of $5,000 per child for that, to help pay for that birth or the adoption planning. So it's a limited one. Like I said, it's not a huge amount of money to take out, but it can be helpful, right? You still have to pay the tax on it. Now it's still taxable money if it's not a Roth account, but you don't have to pay the extra 10% penalty on if it's for that purpose. And then, a very popular topic these days, one of the other exceptions is for certain student loan payments, somebody can take it out without the penalty on it. Now, it's a maximum of $10,000 for the lifetime of that original account holder. So, you couldn't do $10,000 per year to do it. It's $10,000 total. Now, for doctors and lawyers and people with a lot of student loans, that may not make a huge dent, but for a lot of people, that can be very helpful. So that's during the original account holder's lifetime. I mean, this is not including people who maybe inherit these accounts. That at that point, you can use that money because you have to take it out anyway at a certain point. So what this has really changed, like I said, is not so much on the front end of what happens if somebody, it's their account. It's more the planning that goes into it that's changed. Roth conversions were always a really good idea for a lot of reasons, especially if we were looking at long-term care planning at some point for somebody, because it was a huge tax liability otherwise. But the biggest change there is it's now so much more beneficial for a beneficiary to inherit an IRA that is post-tax, so a Roth IRA or a Roth 401k. Really any sort of post-tax retirement account like that, because now they don't have to pay the tax on it. And that is obviously huge, a huge benefit to somebody who maybe is in a higher tax bracket themselves. Because if really the bulk of someone's estate is in qualified retirement accounts and you want everything to go equally, you don't have as much tax planning available for your estate as somebody who maybe has an equal amount of retirement accounts and just traditional investment accounts where they're not specifically retirement funds. So if it's mostly retirement accounts that somebody has, which is the case for a lot of people, then doing that tax planning now is much more beneficial than just saying, all right, one of my kids is in the top tax bracket, the other one's in the lowest tax bracket, but we're still going to give them, we're going to give them all the same amount. And that's fine if that's what you want, but the higher tax bracket child is going to have to, they're essentially going to keep a lot less of what you give them. So that's where, is that actually equal in the long run? Is that what ends up being the case? And there's only so much you can do, I understand, right, with dividing someone's estate and in terms of tax planning, you're trying to be as fair as possible. But if somebody ends up losing a lot more of their inheritance to tax than someone else, just because of the nature of what asset they're inheriting, it may not be what you ultimately thought would happen or reflect your ultimate wishes in terms of how that gets divided. So that's where if you try to do that planning as much as possible, you and your spouse possibly pay the tax on it during your lifetime as much as you can, then you can make them actually inherit equally, right? That's the huge benefit of a Roth is nobody pays any tax at all. So if you somehow manage to convert all of it to a Roth account by the time you pass away, you don't have to worry about that the same way where you're worrying about, well, what happens if one of my kids is in a vastly different tax bracket than the other? Is that actually what I want to happen in terms of, equality or what they actually end up keeping from it, right? So doing that during your lifetime is huge, but it also has changed some of the ways that we plan for them in terms of how they inherit as well. So one of the big considerations we have is we no longer have to worry as much about making sure we can calculate the individual's life expectancy through potentially like a trust fund, right? So that's changed a lot of things there in terms of what we might look at for how we set up your estate plan for your kids. Now, there's a huge problem in terms of certain types of trust that somebody might inherit. And depending on the type of trust somebody has, if it could ever possibly go to anybody other than an individual, so think of it as, sometimes we refer to it as somebody with a heartbeat, right? That's who the IRS considers a designated beneficiary. Well, they get that 10 years if they're a designated beneficiary. However, if it could potentially go down to a charity, organization, maybe a school, anything that is not a person, even if it's a really remote possibility, it could force a 5-year payout for those accounts. So that's not every type of trust that someone might inherit, but it just means that if you have an estate plan and you have a certain type of, you haven't had it updated in a lot of years, or maybe, more than 2 at this point, and you have some type of trust in there that basically says, it doesn't force out all the required minimum distributions to them. They're allowed to choose every year. It's what's called accumulation, or an accumulation trust. If that type of trust has a charitable beneficiary, it says, oh, if I pass away, or if they never end up inheriting from me because they passed before me and it could go down to charity, that could be a problem. That could cause some issues in terms of how long they have to take out those accounts. So they might be expedited. So you want to try to avoid that. And that doesn't mean anybody who's inheriting in trust has that same problem. It certainly depends on the type of document, how those trusts are set up for the beneficiaries. It's going to depend on a lot of things, but it just means that if you haven't looked at it in a while, it's certainly something to ask about, right? So that is something where I would highly recommend anybody who is having their children inherit in trust shares or in a trust fund for their children, whether they're adult children or minor children. If you haven't looked at it in a couple of years, it's definitely a good time to do that, because it may have changed certain priorities that you have or certain backup provisions you have in order to get the best tax stretch for them. So I'm running a little short on time here, but just to remind everybody, again, next week is our in-person wills versus trust seminar. So we're again, if you want to sign up for that, go to estateplanningAppleton.com. So estateplanningAppleton.com. That's where you can sign up. Seating is a little limited still, so just be aware that I would act quickly if you're looking to attend. That'll actually be at the Bordini Center by Fox Valley Tech here in Appleton. So they will be at, there's actually 2 that we're doing. So one's at 2 p.m., the other's at 6 p.m. And they run for about 2 hours. It's kind of what we budget for them, and depending on questions that come up, right? So, if you want to attend to that, it's a really good sort of, general information session on estate planning and sort of why you need to do it, what the difference between certain types of planning is, and you can certainly attend either of those sessions, whatever works for you. You're not limited in which one you choose by any means. I don't see any other questions at this time either. If anything comes up that we didn't get to, or you would like to set up an initial consultation because of the fact that something I've mentioned raised some concerns for you and you want to have your plan looked at, you can always fill out that feedback form where it says, hey, I'd like you to reach out to me and set up a time to talk, or you can just reach out to us directly as well and set up a time. That's completely fine. Whatever is better for you. But again, those are complimentary initial consultations, so you don't have to worry about paying us to come in and just talk initially. At the end of those sessions, where those initial consults, we can usually give a pretty good recommendation about what we need to do and what that cost would look like. But otherwise, I look forward to seeing as many people as we possibly can at our next seminar in person next week in Appleton here at both 2 and 6.